giving. He's back in the news again. Yesterday we discussed how ICAC had said that there was no case to answer, that they didn't believe that there was any misconduct or corruption. They were investigating corruption. However, The Guardian has reported today that he's now been sued in the New South Wales Supreme Court, and I will try and find this case. They're very hard to find. I'm hoping, because the New South Wales government is also a party to this lawsuit, that it will actually become a public interest case and it will be put out there for everyone to see. But it says Jennifer West alleges former New South Wales Deputy Premier as well as Staurt Ayres and Amy Brown acted in breach of their obligations in public office. Now, this is going to be very, very interesting, because if this is found in the court that this has happened, we learnt yesterday that one of the things about the Anti-Corruption Commission was that if there was some issues with their public office. And one of the claims that she makes, according to The Guardian, that I was reading down here, Brown acted for the purpose of enhancing her position and career in the public service, vicarious liable for acts and omissions of Brown. And there was something in here that I was reading before that I thought, oh, that is exactly what the Anti-Corruption Commission didn't say. So let's have a look at this. So it says it's about a personal advantage. So all of this is what would be defined, and we saw this. Oh, that's right. Vicarious liability for acts and omissions of Brown, Ayres and Barilaro constituting malfeasance in public office. Now, that is one of the things that the Anti-Corruption Commission has said that they could not find. And that is one of the things that they deem corruption. So we looked at that yesterday, and I might have to pull that back up again just to have a look, so that we can have a look at that. But it says a woman, it should be the woman, who was initially offered a plum at $500K a year New York trade job, only for it to be given to John Barilaro, has launched legal action accusing the former New South Wales Deputy Premier and former Cabinet Minister Staurt Ayres of misusing their power. A statement of claim filed in the New South Wales Supreme Court alleges Barilaro, Ayres and the former head of Investment New South Wales, Amy Brown, each engaged in malfeasance in public office over the trade saga. The lawsuit was brought by Jennifer West, a business person and former public servant, who was originally offered the trade role, which eventually was given to Barilaro. On Monday, ICAC, the Independent Commission Against Corruption, revealed that after an 8-month investigation, in which it compelled various people to provide evidence and documents, it found no evidence of corrupt conduct. But a statement of claim lodged this week on behalf of West alleges the 3 officials committed actions during the appointment which were in breach of their obligations in public office and were insulting and humiliating for her. It alleges that despite Brown verbally offering her the role, including being shown a signed briefing from the then Premier Gladys Berejiklian recommending her for the job, Barilaro, then Trade Minister, had intervened to suggest the job instead become a ministerial appointment, leading to the offer being withdrawn. A New South Wales parliamentary inquiry into the matter heard West claim that she was told by Brown the job would be given as a present to someone. Brown denied saying that. The statement of claim alleges that Barilaro had sought the role for his own personal advantage, while Ayres, a former Deputy Liberal leader who replaced Barilaro as Trade Minister, resigned from Cabinet over the saga, allegedly acted for the purposes of enhancing his political career and to provide benefit to Barilaro. Brown acted for the purpose of enhancing her position and career in the public service, the document alleges. The suit, which is seeking aggravated damages, also names the state of New South Wales as co-defendant, claiming it is vicarious liable for the acts and omissions of Brown's Ayres and Barilaro, constituting malfeasance in public office. Barilaro's appointment caused a storm over a controversy last year when it was revealed West had initially been offered the job. A long-running New South Wales parliamentary inquiry into the saga last month released a report finding the recruitment for the role had been flawed and showed all the trademarks of jobs for the boys. It also found that the treatment of West was unfair, unprofessional, and sends a terrible message. West was also terminated from her role after trade job was rescinded, and the statement of claim alleges that was to remove West from a position in which West could potentially embarrass Brown, Ayres and Barilaro, a government. It claims the three defendants acted knowingly. West would suffer reputational and economic damage over the saga. Brown declined to comment. Barilaro and Ayres have been contacted for detail. The matter is heard in court next week. Now, this is the thing about journalists, is that they've contacted all the parties now to see what they've got to say. So let's go back and have a look at what ICAC says. ICAC, New South Wales. Here we go. So let's have a look at one of the reasonings. What is corrupt conduct? So we looked at this last night. Let's have a look at it again, because I'm very interested to see what it was. So it says, what is corrupt conduct? So let's have a look. So some examples are, we looked at it last night. So improperly using the information. What is corrupt conduct? A member of the no, well, he was a member of the public then. So, conditions that why. So they expect the public officials to act honestly. Okay, so that's what they're saying. It's the intentional wrongdoing, not negligence or a mistake. It has to involve or affect a New South Wales public official or public sector union organisation. So it could be that it could be negligent conduct, which means it wouldn't be corrupt. So let's look at malfeasance in public office. So common law, because only public officials, and they must have acted unlawfully in the sense that they exceeded or misused a public power or position. So it's a very peculiar tort. So this is from the Australian government solicitor. And it looks like that is a form of intentional tort. It is the only tort recognised by common law that has an exclusive public law option. It's been described as a very peculiar tort. It's 300 years old. Despite being the subject of hundreds of decided cases, there's certain things that are uncertain to this. So the elements of the tort, they must be a holder of public office. They must have purportedly exercised the power that was an incident of that office. The defendant's exercise of power must have been invalid or otherwise lacking authority. The exercise of power must have been accompanied by one or other of the following forms of bad faith. The defendant must have exercised the power knowing that he or she was acting in excess of power and with the intention to cause harm to the plaintiff. sometimes referred to as targeted malice. The defendant must have been recklessly indifferent to whether the act was beyond power and recklessly indifferent to the likelihood of harm being caused to the plaintiff, and the exercise of power must have been productive of loss. And so this is the first element, and then there's some case law about that. Exercising public power. So there's again some cases here. Do we got the third element here? Ooh, where's the third element? The third element, lacking authority. So in the context of this, courts have found the third element to be satisfied in the following circumstances. Delegated legislation in the form of disallowable legislation instrument where the instrument was considered to be unreasonable exercise. Imposition of movement and quarantine restrictions, the use of warrant powers to record contents of documents, correspondence from the CEO of a shire council prompting authorities to take regulatory action against a pharmacy where the correspondence utilised the authority of the officer for an ulterior and improper purpose. So there are limits or procedures governing the matter of their exercise may be breached without resulting in validity. See Project Sky Blue versus Australian Broadcasting Corporation. So bad faith, mental element. So it talks about the defendant's intention of state of mind. With the intention of causing injury or damage to the plaintiff. And then there's some more here on targeted malice. No knowledge, reckless indifference. I'd say they had reckless indifference. I just don't know that they really cared. Can the Commonwealth be vicarious liability for its employees? For ministerial. So, I mean, we're not talking about the Commonwealth in this case, we're talking about the state, but it remains unresolved, according to this article from the Australian Government Solicitor. This is the Solicitor General. Fernando Commonwealth proceeded on the basis of what perhaps mistakenly understood to be a concession by the Commonwealth. It was vicarious liability for any misfeasant act which may have been found against the minister. So remember, so this was written by the on the federal with assault and battery and false imprisonment. It's classified as an intentional tort. In the case of intentional tort, a claimant may recover general damages for both the wrong and any consequential loss that is not too remote. The most generous test for recoverable losses, less than reasonable foreseeability, which applies to actions in negligence and other intentional torts. So you have intentional torts, assault, battery, and false imprisonment, and then you have unintentional torts where negligence comes in and then reducing the risk. So yes, so that's really what that is, but that's the elements that are in that. So it's interesting because it's actually in the Supreme Court, not the federal court, because the federal court actually has set a high bar for this tort. So that's very interesting. So again, another article. So it's going to be very interesting to see how this plays out. So in Northern Territory versus Mengle in 95, the mental element is satisfied when the public officer engages in the impinged conduct with the intention of inflicting injury. No thanks. I don't want to register. I didn't want to do it. Oh, great. It's not found. Thank you for that. Oh, how embarrassing, hey? I can't see that on my screen. It's funny. I've lost it on my screen. Oh, there we go. These are states of mind which are inconsistent with an honest attempt by a public officer to perform functions of the office. Another state of mind which is inconsistent with an honest attempt to perform functions of a public office is reckless indifference as to the availability of the power to support the impugned conduct, as to the injury which the impugned conduct is calculated to produce. So then here's a case here. Background of plaintiff M83A was a class action by, looks like it was a immigration case. So that was from this one. So yeah, so it's going to be very interesting, because if she if she can prove, for example, that there was something dodgy going on, it could be very, very interesting. So this was, University of Melbourne here. Who wrote this? So that's what we're really talking about. This is Mark Anderson. This is malfeasance in public office, a very peculiar tort. Yeah. So, yes, so it's essentially negligence, I guess, in their position. So anyway, that's all I've got for you. Thank you for joining me, and I will catch you again next time. Please make sure you hit like and subscribe. If you want to support the channel, you can do a super thanks. You can join, become a channel member. You can, there's places that you can donate if you want to support the channel, help me grow. But other than that, just like and share and subscribe.